All right, oui, vous l'avez. Please be seated. Veuillez vous asseoir.
Just on timings, Mr. Lightship, we worked out, I think, that you've got an hour and a bit. I'm not sure what the bit was, but we may start on the questions, but what we're going to do is shorten the lunch hour again for an hour and a quarter, to an hour and a quarter, whatever time you conclude. Sorry, you've got 1 hour 20, so that actually takes us up to lunchtime anyhow. Yeah.
My intention, Madam President, is to carry on speaking for roughly 40 minutes.
Yeah.
And so that Mr. Abd-Al-Rahman will have 20 minutes for his own answering statement.
Well, you've actually got an hour and 20 left.
Okay, well good news.
So you can slow down even more. Actually, you've been doing very well, if I may say so. Yeah.
Thank you.
Yes, whenever you're ready.
Okay. Thank you, Madam President. L'élément de preuve suivant.
The following piece of evidence that I'm going to deal with is the surrender video. And what follows will also answer question number 2 of the chamber. Unlike the legal representatives of the victims who devote 5 paragraphs of their brief to the video, the Office of the Prosecutor only mentions it very timidly, mentions the video very timidly in paragraph 62 of their brief. The timidity of the OTP is consistent with their attitude during the confirmation hearing. Let me remind you that this video was only finally taken out of the OTP's hat as a rebuttal evidence at the very end of the hearing. This is transcript 9, page 38 to page 40. If the Office of the Prosecutor had been more comfortable with the use of the video, then there is no doubt that it would have made it its number 1 piece of evidence. These findings were upheld by the Appeals Chamber in its judgment OA12. The Appeals Chamber only allows the video to be considered as evidence of Mr. Abd-Al-Rahman's identity and expressly excludes any use of the video as evidence of any other disputed aspect. This is paragraph 93 of OA12. And so it is clear the video cannot be considered as evidence of facts relating to the guilt of or innocence of Mr. Abd-Al-Rahman. This conclusion is clear and unequivocal. And if I can allow myself to say so, this was implicitly admitted by your chamber. If the circumstances in which this video was obtained did not prohibit its consideration as evidence as to the acts and conduct of the accused, then all of the information mentioned in it could be used as evidence. Yet, at paragraph 90 of their brief, the legal representatives of the victims drew attention, and I am kicking myself for having not noticed it before them. They drew the attention to an error in the transcript of the video, and they quoted the transcript that said, "I killed it, I admit it, people in Darfur." And that is not what Mr. Abd-Al-Rahman says in the video. And the defense asks for this retranscription to be verified. What he says, in fact, is they, the government, have nothing to do with the truth because they said that I was a terrorist and that I had killed people in Darfur, and I am an ordinary man. So I request this video, the retranscription, to be verified. But in any event, the fact that this erroneous transcript contains an admission that Mr. Abd-Al-Rahman committed crimes is something that's interesting. No one at any point Not the Office of the Prosecutor in their brief, nor you, ladies and gentlemen of the court, ever considered considering this highly incriminating erroneous sentence as evidence of Mr. Abd-Al-Rahman's guilt. Why did you not do so? Well, quite simply because you know the law, and you know that in the circumstances in which the video was obtained, in breach of Article 55, paragraph 2 of the statute, this video cannot be admitted into evidence under Article 69, paragraph 7 of the statute, and the appeals chamber confirmed this. No one in this courtroom can today dispute the fact that the alias Ali Kushaib is a central issue in the case submitted to your chamber for deliberation. This is a question that is inseparable from the determination of the guilt or innocence of Mr. Abd-Al-Rahman. It is the first of our lines of defense. The Office of the Prosecutor and the legal representatives of victims devote an important chapter to this in their briefs. To conclude that the evidence does not establish beyond reasonable doubt that Mr. Abd-Al-Rahman is Ali Kushaib, and you'll have no other option but to acquit him of all the charges against him. This question is thus undoubtedly one...
Okay, sorry. Either I can deal with it now, or wait till this afternoon, because I tell you what, we'll come back to it this afternoon in the light of what you've said.
Je vous remercie.
Thank you very much. So what I was saying was this issue of the alias was without a doubt an issue for which the appeals chamber excludes the use of the video under Article 69.7 of the statute in paragraph 93 of its judgment. The video cannot therefore be used as evidence and does not have any probative value for the reasons given in paragraphs 186 to 189 of the defense brief. Before moving on, I would also like to point out that the Office of the Prosecutor bases itself on paragraph 62 of footnote 214 on a document that is not in evidence and should thus be ignored. The next piece of evidence is the alleged interview with Mr. Abd-Al-Rahman Ali Kushaib in November 2006. The defense was surprised. It was surprised to note the extent to which the Office of the Prosecutor used this interview as evidence of Mr. Al-Rahman's guilt in its brief. Throughout this trial, the debate related to this interview was essentially limited to its authenticity or to its link with Mr. Abd-Al-Rahman. The defense contested the signature and argued that Ali Kushaib's age and position in the popular defense forces did not correspond to that of Mr. Abd-Al-Rahman. And these are essentially the points that the Office of the Prosecutor also addresses in paragraphs 32 to 41 of their brief. Before moving on, I would like to say that the date of this interview, November 2006, is problematic because even though it dates from 2006, it was only received by the Office of the Prosecutor in 2021. And the recipient is in the room right now. If the interview is fake, the Sudanese authorities had 15 years to prepare it. In paragraph 37 of their brief, the Office of the Prosecutor submits that witness D35 would corroborate the existence of this interview, referring to an investigation that took place in 2007. This is an anachronistic submission. D0035's information about a 2007 investigation cannot confirm an interview that allegedly took place in 2006. No credible evidence corroborates the authenticity of this interview. The OTP who had the opportunity to call witnesses in response, who had the opportunity of calling the Sudanese author of this interview, who was identified by witness D16, did not do so, and thus failed in their task to prove the authenticity of the interview and to prove that Mr. Abd-Al-Rahman was indeed the person interviewed. However, despite the mention of his name, Ali Muhammad Ali Abd-Al-Rahman, everything indicates that if this interview is authentic, which is disputed, the person interviewed is not Mr. Abd-Al-Rahman. First of all, his age, 40, whereas Mr. Abd-Al-Rahman was 57 in 2006. His position within the Popular Defense Forces, of which Mr. Abd-Al-Rahman was never a member, the correspondence with Ali Kushaib, whom witness D16 met in June 2006 in Khartoum, this is item 82, and finally, the document dated 3rd of December 2024, sent by the Sudanese authorities. In English, this is item 168, which confirms under heading C that Mr. Abd-Al-Rahman does not appear in the Sudanese register of prosecuted and convicted persons. All of this shows that this interview cannot relate to him. Witness D0035 confirmed that he was well placed to and he was very well placed to say so. He confirmed that the Sudanese judicial register included not only convictions, but also included persons under criminal investigation. I will cite his declaration, DA 3100-514, and he stated,
if the individual has been convicted, but we can also see if the person has been accused or has been under investigation. We can see all the steps in the criminal records. So, if a person has been investigated, that will appear in his criminal records. Je reviens au français. Ce point n'a pas été contesté.
Back to French. This point was not contested by the OTP in their cross-examination of witness 0035. The fact that Mr. Abd-Al-Rahman does not appear in the Sudanese register is thus proof that he is not the person under investigation who was questioned in November 2006, so either this document is a forgery or the person interviewed is someone else. On Wednesday, we saw the extensive use that the OTP did of this interview. And they used this document as a statement of Mr. Abd-Al-Rahman in his own case. My colleague even spoke about it as a declaration pursuant Article 55, paragraph 2 of the statute. And you will find this on the transcript, page 25, line 3 to 8. But this was not a declaration. The 2006 interview, like the video of the surrender, was not preceded by any of the guarantees required by Article 55.2 of the statute of the court. The minutes bear no mention of the fact that the interviewee had been informed that there were grounds to believe that he had committed a crime, no mention to his right to remain silent, no mention of his right to the assistance of counsel, no mention of his right to be questioned in the presence of counsel, and indeed he is not assisted by counsel. Ali Kushaib is not the only witness to have been questioned by the Sudanese authorities in relation to the events of 2003. Witnesses P0878 and P0883 were also last questioned, and both confirmed during their testimony that the transcript of their interview had not been read back to them and that they were not asked to sign it. P0878 stated that the Sudanese prosecutor told him that he was being questioned as a witness and did not tell him that what he might say could be used against him. Witness P0883 said that, according to him, he was not in any way free not to answer the questions put to him. This is item 61. And for the other witness, 0878, that was item 67. So their testimony confirms the failure to respect the guarantees of Article 55.2 of the statute and reveals the signature affixed to Ali Kushaib's alleged statement as a further anomaly. The court has consistently held that evidence obtained in violation of Article 55.2 of the statute or international human rights guarantees are inadmissible as evidence under Article 69, paragraph 7 of the statute. The appeals chambers confirmed this in the Lubanga case. This is item 25, and in the Bemba and others case, and this is item 35. The appeals chamber directly referred to this excerpt of the Bemba and others case in paragraph 82 of its judgment, of its 0812 judgment regarding the video. And so this case law is therefore relevant in this present case. By virtue of Article 69, paragraph 7 of the statute, this case law therefore precludes the use in evidence of the alleged transcript of November 2006 proposed by the Office of the Prosecutor. So, as a conclusion on line 1, the burden of establishing the identity of Mr. Abd-Al-Rahman as Ali Kushaib rested with the Office of the Prosecutor. The Ali Kushaib described in the evidence presented by the OTP, first of all, was 40 years old in 2006 and would therefore have been born in 1966, whereas Mr. Abd-Al-Rahman was born in 1949. There's a 17-year age difference there. Ali Kushaib would allegedly be from the Rizegat tribe, this is in items 96 and 170, or from any other non-Arab tribe of southern Sudan, item 171, whereas Mr. Abd-Al-Rahman, as to him, is from the Taisha tribe. Ali Kushaib was a member of the Popular Defense Forces, which Mr. Abd-Al-Rahman had never been a part of. Ali Kushaib was purportedly an Agid al-Ogada of a tribe, whatever that tribe may be, whereas Mr. Abd-Al-Rahman has never been Agid al-Ogada of his Taisha tribe. Ali Kushaib had been prosecuted by the Sudanese authorities and is therefore listed in the Sudanese judicial register, whereas Mr. Abd-Al-Rahman is not. Ali Kushaib is reportedly hunchbacked. He's a sort of Sudanese Richard III, unlike Mr. Abd-Al-Rahman, who stands remarkably straight for his age. Ali Kushaib also has scarifications, ritual scarifications on his forehead and on his cheeks, whereas you need only take a glance at Mr. Abd-Al-Rahman sitting behind me to see that he has no such scarifications. Ali Kushaib has pierced ears, unlike Mr. Abd-Al-Rahman. And so I turn around and I can see that the man I have just described, Ali Kushaib, is not sitting behind me. And so the only reasonable conclusion that your chamber can draw from this evidence is that if this Ali Kushaib exists, he is not Mr. Abd-Al-Rahman. Now for line 2. Mr. Abd-Al-Rahman was never a Janjaweed, let alone their leader.
Comment prétendre
How can one claimed that a defendant acted in capacity of an Agid al-Oghada, exercising the functions of supreme leader of the Janjaweed militias, without defining what an Agid Oghada is, nor what the Janjaweed militia are. It seems absurd, but that is indeed what the Office of the Prosecutor has done in this case. Neither the alleged position of authority, Agid al-Oghada, nor the group over which this authority was supposed to have been exercised are defined by the OTP. This is a clever strategy. By not defining what it should prove, the Office of the Prosecutor could hope to avoid the burden of proving it. And it is only before yesterday, thanks to the Chamber's question, Your Honours, that the clarification of the position of the Office of the Prosecutor was made. I'm in transcript 160 in English, page 66-67. And in summary, the Fursan were Janjaweed, and we agree on that. The Popular Defense Forces were generally perceived to be Janjaweed, and we also agree on this point. But Mr. Abd-Al-Rahman's militia did not belong to the Popular Defense Forces. Of course, that would be better, because otherwise, if Mr. Abd-Al-Rahman's purported militia had belonged to the Popular Defense Forces, then you could acquit Mr. Abd-Al-Rahman today and send him home for Christmas. But that raises a question. In that case, what was Mr. Abd-Al-Rahman's alleged militia? We never heard speak of a separate militia. There's no Kushayb's boys in this file, neither in the OTP's brief. The Janjaweed who is mentioned, and Ali Kushayb is supposedly their supreme leader. That's all or nothing, and this all is not defined. The appeals chamber, I'd like to answer your question. I'm answering the question 22 of the chamber. The appeals chamber clearly set out in its judgment in the Lubanga case that the scope of the burden of the proof also applied to the mode of liability of the accused. In this present case, Mr. Abd-Al-Rahman is accused of having contributed to the crimes as a direct perpetrator under Article 25.3 of the statute, and as co-perpetrator under Article 25.3 still of the statute, and as a principal and a person who incited the commission of the crimes under Article 25.3b of the statute. Under the appeals chamber, the Office of the Prosecutor was responsible for proving the elements constituting these three modes of liability. The principal's mode of responsibility clearly requires proof of the accused's position of authority. This is one of its inseparable constituent elements, and the OTP agrees with this in paragraph 204 of their brief. The burden of proving this therefore lies with the OTP. Incitement under Article 25.3 requires at least that the accused was at least in a position of authority, and if not that, then at least in a position of influence over those who committed crimes. This position of influence may be the result of several factors. The one chosen by the Office of the Prosecutor in paragraph 208 of their brief is Mr. Abd-Al-Rahman's alleged position of authority.
The Office of the Prosecutor never alleged that the status of pharmacist of Mr. Abd-Al-Rahman would have enabled him to exercise any influence on Janjaweed militias. It was his alleged status as a supposed Agad al-Oghada and head of Janjaweed militias that, according to the theory of the prosecutor, was the basis for his position of influence. The co-perpetration under Article 25.3a requires proof that the accused gave an essential contribution to the execution of the common plan. This contribution, essential contribution, was defined in the appeals chamber in the Ongwen case. the person has to have had control over the commission of the crime or by contributing to it, and the power to prevent it. And this is item 38, and I quote paragraph 203 of the brief. In paragraph 203, the OTP relies on the position of authority and alleged influence of Mr. Abd-Al-Rahman as chief of the Janjaweed militias as evidence of him contributing to the crimes. The OTP does not retain in its brief a distinction that was used by the pretrial Chamber 2 between direct perpetration and joint perpetration, but puts them together in a notion called direct co-perpetration. Conversely, pretrial Chamber 2 had made the distinction between the two and had only confirmed some charges under the mode of responsibility as the direct perpetrator, that is, the charges 2 to 16 and 21, and 22 to 24 for Delage. And there was there's the alternative. So without the authority over the Janjaweed, this pharmacist from Garcilla would not have anything to do in Mukjar or Delage and would not have even had access to the prisoners in order to threaten or mistreat them. So the OTP makes the entire role of Mr. Abd-Al-Rahman in Mukjar and Delage, and even as the direct perpetrator, on this supposed position as an authority of the Janjaweed militia. And there is the alternative scenario, according to which Mr. Abd-Al-Rahman would have acted without authority, for example, just as a pharmacist. That was never part of the theory of the OTP. The defense never got any warning of this alternative scenario and therefore was not able to present any evidence or respond to it. So it is up to the Office of the Prosecutor to prove this alleged position as the head of the Janjaweed to establish his influence or authority on these militias. For that, it would have had to establish what the Janjaweed are and what an Agid al-Oga is. This was not done. The Office of the Prosecutor could have proceeded differently. Could it have proceeded differently and established responsibility of Mr. Abd-Al-Rahman without proving the position of the authority on the Janjaweed militias for modes of responsibility under 25.3b of the statute and Article 25.3a? He would have, the OTP would have had to prove independently of the alleged authority that Abd-Al-Rahman had made an essential contribution to the execution of the common plan, had exercised control the commission of the crimes and could have prevented them. Again, I'm referring to the Ogwen judgment, and thus, each time the OTP places Abd-Al-Rahman exclusively in the position of command, such as the attacks on Kudum and Bindizi, the mode of responsibility under Article 25.3a of the statute is not retained. And if the proof of a responsibility has not been proven, he cannot not be deemed responsible for the crimes committed in Kudum and Bindisi. For Mukjar and Delage, according to the OTP, the evidence of all the acts of direct co-perpetration are also founded on this alleged authority of Mr. Abd-Al-Rahman over the Janjaweed militias. And without this authority, he cannot either be held responsible for these acts. Even when Mr. Abd-Al-Rahman is accused of threatening or physically attacking people in Mukhtar and Daleg, the defense submits without a minimal proof within the Janjaweed. He cannot be held responsible, even if it is a matter of him supposedly directly perpetrating this. He could not have done this without being an actual Janjaweed, irrespective of his rank. The Janjaweed militia in operation in Mukhtar and Delij would never have let someone whom they did not recognize as one of their own approach their prisoners. Mr. Abd-Al-Rahman is neither a resident of Mukhtar nor a resident of Delij. It is admitted that he was living in Garcilla. So he was in the category of people who were suspected and arrested, either, and I refer to item 113, the statement of witness 922. Even if he had not been arrested, Janjaweed militias would not have let him approach their prisoners without a valid motive. And the only valid one could have been that he was a Janjaweed himself, irrespective of his rank. But the Office of the Prosecutor did not prove that Mr. Abd-Al-Rahman was a Janjaweed militiaman, and even less so their leader. The Office of the Prosecutor did not prove nor even suggest the existence of a distinct militia. I spoke of the Kusheb's boys, at the head of which Mr. Abd-Al-Rahman would have been in a position of authority. The theory of the prosecutor is that he was the head of all the Janjaweeds. The Office of the Prosecutor, in paragraph 80 of its brief, talks about the terms used, Fursan, Peshmerga, and Mujahideen, but does not define them as a distinct group at the head of which Mr. Abd-Al-Rahman would have been. It does not define these terms or the alternative terms. The defense proves that the Fursan are a particular group of cavalrymen belonging to nomad Arab tribes, especially Ben al-Bab. But Mr. Abd-Al-Rahman is Taisha, and the Taisha tribe is sedentary, so he could not have been a Fursan, and let alone not being its leader. With regard to Mujahideen, it's a word often used to designate volunteers of the Popular Defense Forces, items 54, 56, 94, and 115. In paragraph 78 of its brief, the Office of the Prosecutor recognizes the Janjaweed militias and Popular Defense Forces as being often considered one and the same thing. The defense is a bit more specific on this and explains with evidence that the Janjaweeds are a mix of three groups: the Popular Defense Forces, the Border Guards, and the tribal militias. But the Office of the Prosecutor never maintained that Mr. Abd-Al-Rahman would have been part of the Popular Defense Forces, and even excluded that on Wednesday, or the Border Guards. In 2003, he was 54, so he was too old to join the reserve forces, items 79 and 149. So the last solution was these tribal militias. And again, Mr. Abd-Al-Rahman can not have belonged to a tribal militia for three reasons. The first is that his tribe, the Taisha, refused to join the counterinsurgency of 2003, 2004 in Wadi Saleh and Mukhtar. This evidence has been reported by witnesses P20, P585, P1040, D1, D2, D03, D07, D36, and D39, items 51, 85, 86, 87, 89, 88, and 150. This information was not disputed by the Office of the Prosecutor, that does not prove the contrary. The reasons for them to refuse being part of the militias are multiple. It's because, first, there was a strong presence of the Four on the Taisha territory. So entering into war with the Four of Wadi Salah would have had immediate consequences for peace and security of the Taisha Dar. The second is that Mr. Abd-Al-Rahman had respected the decision of the Taisha Nazir not to join the counterinsurgency. And if he had done this, this would have had serious consequences on his social status within the Taisha tribe, going as far as possible banishment, items 87 and 88, or less serious consequences, equivalent to a disgrace, item 45. This is Alex Dewal, the expert who had spoken of this. Yet, the evidence in the case shows that they're very far from being banished or disgraced. Mr. Abd-Al-Rahman continued to be a person respected within his tribe. The videos and statements made by the Sori and professors attest to this. The Office of the Prosecutor did not dispute either the designation of Mr. Abd-Al-Rahman as a mushrif upon his return to Rahad el-Berdi around 2009, and it even refers to this in paragraph 198 of its brief. Third reason is that the Janjaweeds of Wadi Salah were in the majority from the Salamat tribe, enemies of the Taisha. And question 27 of the chamber about the proof of the Salawite constitute an essential element of the Janjaweed tribe. And this information is given by the witness, Alex Dewal, talking about the obsession of the Salamite to conquer new lands of the Four in order to obtain their own Dar and their Nazir. The Salamat were the majority Arab tribe in Mukjar, and they significantly entered or enrolled into the Janjaweed militia, item 45. This information, up until Wednesday, has not been contested by the Office of the Prosecutor. This information is corroborated in the National Investigation Report under DAR OTP 01160380, page 398, item 30, which talks of tensions in the region and the formation of armed groups by some Arab tribes, the Beni Alba and Salamat, to attack the Four villages. Likewise, witnesses P907 and P1021 both mention the Salamat as being part of the main Arab tribes of Wadi Saleh and Mukjar, and also their recruitment into the Janjaweed militias, items 68 and 72. With the Janjaweed militias being mainly Salamat, there was no chance that a Taisha such as Mr. Abd-Al-Rahman would have been chosen to be their leader. I had said this at the beginning of my pleading, that they would have rather slit his throat. By refusing to define the Janjaweed militias, the Office of the Prosecutor was not able to prove what these militias are, nor that Mr. Abd-Al-Rahman had joined them in any capacity in 2004-2005. The only conclusion that's reasonable is that Mr. Abd-Al-Rahman was never part of the Janjaweed militias. The Office of the Prosecutor tried to overcome this burden of proof that he was a Janjaweed by saying that he was an Agid ol Ogada, but they didn't do this either. If they had, they would have realized that the authority attached to this position is limited to one's tribe. And even if he had been Agid al-Ogada in 2003-2004, he would have only had authority on the Agids of the Taisha tribe that did not participate in the counterinsurgency. The Agid Ogada of the Taisha tribe in 2004-2005 was the late Ahmed Ibrahim al-Semeh al-Ghani, who passed away in early November 2024. May he rest in peace. Mr. Abd-Al-Rahman could not, therefore, have either been Agid I'll start again. He could therefore not be an Agid al-Ogada, and the witnesses of the offices of the prosecutor who said this obviously had just regurgitated the information made public by the Office of the Prosecutor on 27 February 2007 and widely spread in the media. The Office of the Prosecutor also tries to establish the so-called authority of Mr. Abd-Al-Rahman, basing itself on the fact that he would have presided over some obscure Mujahideen subcommittee of the Security Committee of Garcella. This information is based on one witness's testimony, P643. It's contradicted by P1021, who explains that the function of recruiting Mujahideens is one of the coordinator of the Popular Defense Forces, and corroborated by D36, item 86, and indicated that the Committee of Security of Mokjar did not have a Mujahideen subcommittee, item 6869. P643 is also contradicted, explaining that the Mobilization Committee, whose Mujahideen subcommittee, which was supposed to be a subdivision, was part of an administrative structure of the reserve forces, items 79 and 149. Mr. Abd-Al-Rahman was too old to be part of these forces in 2003. In paragraph 142 of its brief, the Office of the Prosecutor mentions the possession of a Thuraya telephone by Mr. Abd-Al-Rahman as proof of his authority. It relies on the testimony of witness P883, according to which this artifact would have been reserved to the greatest chiefs, including Ali Kashib. But P883 lies again on this detail. Proof of this lie is contained in paragraph 110 of the prosecutor's brief, mentioning the Thuraya telephone in the list of basic equipment provided by the government of Sudan to the Janjaweed militias, just as they received uniforms, weapons, ammunition that is, and food for the horses. P921, who was not a leader, testified that he had a phone, and that's item 77. P1021 testified that the Janjaweed, Sameh, and Bonjus also had phones, item 68. The possession of a phone, therefore, in no way is a sign of authority. Even if Mr. Abd-Al-Rahman had one, which is disputed, this would not have made him a Janjaweed leader. And finally, in paragraph 195 of its brief, the Office of the Prosecutor dares compare Mr. Abd-Al-Rahman to the known Janjaweed leaders, asserting that he was promoted after the events in 2003-2004. But the rank of Musaid, that is warrant officer, which was given to him in the Central Reserve Forces starting in 2005, does not constitute in any way a promotion. It was the rank that he had in the Sudanese Armed Forces when he retired, item 93. He was never promoted, hasn't been promoted since, and he still has that rank, as he had in 2020. These are items 89, 159, 160. His salary as a Musaid in January 2020 was 660 Sudanese pounds. With the exchange rate at the time, that is the equivalent of 13 euros a month. Items 159 and 160. He earns more in detention since his arrival here than he was at the time. So we are very far, you will agree, from the prestigious fate of Lieutenant Colonel Chakrutala, Brigadier General Bonjous, or Vice President Hemeti. Mr. Abd-Al-Rahman was never promoted, and this is one more a source of proof that he was never a Janjaweed. Conclusion on line 2 of the defense. Mr. Abd-Al-Rahman never had any control on the Janjaweed, so he had no control over the perpetration of crimes in Kudum, Bindisi, Mukjar, and Delej, and he was not even in a position to prevent them from being committed. The position of the defense is that he simply was not there. The main protagonists of these 4 crime scenes are known. My colleague indicated them, but I recall them. In Bindisi, we have, for the Central Reserve Forces, Himeidan, and, no, I won't say this. And we have the Commissioner Abd-al-Hakam. We have the 3 witnesses. We have witness, and for the popular defenses, we have Hasbala, and for the Janjaweed, we have Bonjous, Sameh, and Daoud Dahab. That suffices. I don't need to add another Ali Shakib. And we have in Mukjar, the Commissioner Torshain. We have the first Lieutenant Amdi wearing 2 hats from military intelligence and a commander of the Popular Defense Forces. We have Al-Taib for the Central Reserve Forces, Al-Jalili for the police, and the Janjaweed, Aldouit Sameh for the Janjaweed. So everything described in the charges not disputed by the defense could have happened without adding Ali Kushaib. And finally, in Delej, we have, once again, Lieutenant Hamdi, Hasabala for the Popular Defense Forces, the so-called Mukadem Idris for the Sudanese Armed Forces, and Juma Farali for the police. All the people I have just mentioned have de jure and or de facto, and it's often both, on the perpetration of crimes. Their authority has been proven, it is known, but largely it is not disputed between the 2 parties. The only thing is to know whether Bonjous and Sameh were subordinates of Ali Kushaib. So without any authority de jure or de facto, Mr. Abd-Al-Rahman cannot be held responsible for the crimes mentioned in the charges and, I recall, must be acquitted.
J'en passe à la ligne 3 et
Okay.
je manque de temps.
I'm running out of time, so I will ask the legal representatives of the victims, because I will not answer to this line. So I will look at paragraph 683. The Office of the Prosecutor negligently omitted to prove and plead that Mr. Abd-Al-Rahman had been informed of the criminal nature of the acts he's accused of. The OTP, again, Wednesday, owned this negligence and justified it in paragraph 683 of its brief, and asserts that Mr. Abd-Al-Rahman was aware of the criminal nature of the acts he's accused of, and recites the first sentence in Article 32(2) of the statute. The prosecutor concludes that it did not have to prove any absence of error on this point, and in fact reverses the burden of proof, saying that no sufficient proof had been submitted that Mr. Abd-Al-Rahman would have acted by error. Under Article 66(2) of the statute, the burden of proof of the guilt of Mr. Abd-Al-Rahman falls to the Office of the Prosecutor. That burden of proof applies to each of the elements of the crime of which he's accused, including the moral element. The elements of the crimes require proof of the intention and knowledge. This evidence can be submitted directly or through inference, but it must be proven. Intention and knowledge cannot be presumed, as the Office of the Prosecutor proposes to the Chamber to do. The first sentence in Article 32(2) of the statute, on which the OTP relies to try to avoid bearing its burden of proof, is of no relevance in this case, as the Appeals Chamber in paragraph 87 of the OA8 judgment, the statute, that is the statute of the court, was not in force in Sudan at the time of the events. The question of knowing whether the acts mentioned in the charge constitute crimes under the jurisdiction of the court, to which the answer is no, has no relevance for the determination of the moral element. Second sentence that's quoted in 32(2) is highly relevant, and I read, an error of law can be a motive for exoneration of the criminal responsibility if it leads to a disappearance of the psychological element of the crime. The psychological element common to all crimes defined by Article 30 of the statute includes, under paragraph 3, knowledge that a circumstance exists or a consequence could come about in the normal course of events. It includes, therefore, the knowledge of the criminal and prohibited character of events mentioned in the charges, and the lack of obligation to commit them once they're ordered by a person who is acting with authority. And it's also included the knowledge that criminal proceedings would be initiated if they were to be committed. The burden of proof of the knowledge of Abd-Al-Rahman in terms of the criminal and prohibited nature of the acts, the lack of obligation to commit once ordered by a person acting with authority, and the fact that if their perpetration would lead to criminal proceedings is something that falls to the OTP. It could have been dealt with by by giving direct evidence of this knowledge or inference, but neither option was taken. It was not even pleaded, although this had been informed to the OTP that the absence of knowledge was one of the lines of defense of the defense. In paragraph 683, the OTP's brief says that it admits not having done this. When a prosecutor deliberately refuses, and with such obstinacy, to bear this burden of proof of guilt, well, the only reasonable response of a chamber is to acquit the accused. The chamber cannot just be the one that has to go and seek out the proof that the OTP has not done so. And the moral element that the prosecutor refuses to prove is common to all crimes mentioned in these charges. And that is why a total acquittal is what the chamber has to come to as a conclusion, given what the Office of the Prosecutor has done. Even if your chamber had been convinced that Mr. Abd-Al-Rahman had committed something, if he had been working in his pharmacy, or he could have done something that could be considered criminal.
Now for the general conclusion of my closing arguments. From the outset of this case, the defense, citing Leviticus, argued that Mr. Abd-Al-Rahman was what in Greek is known as a pharmakos. Now, this is not a pharmacist, but a scapegoat sent into the desert in order to atone for the sins of the children of Israel. So he was offered by the government of Sudan to this court to satisfy it and divert its attention from President al-Bashir and other senior officials. This theory, and it was just that, was magnificently confirmed by the fact, and this is a fact which the defense was unaware of when it formulated this theory, the fact that the prosecution of Mr. Abd-Al-Rahman had been suggested to the court by the government of Sudan in May 2005, meaning only 2 months after Security Council Resolution 1593. This is item 126. The defense theory was also validated by Hassan al-Turabi himself. I'm referring to the architect of the military coup of 1989, someone I would call al-Bashir's maker, who stated this in a press conference on the 14th of October 2008. This is item 178, and at that time he described Ali Kushayb as a scapegoat for Bashir. The fact that Mr. Abd-Al-Rahman is a scapegoat does not as such answer the question of his guilt or innocence. A scapegoat is not necessarily innocent. Witness P0547 referred to the errant officer technique as a classic means in Sudan of deflecting responsibility for crimes committed by the country's authorities. This is item 54. What the evidence of Mr. Abd-Al-Rahman being a scapegoat does tell us, however, is that he is not important in the eyes of Sudanese authorities. He is what in international criminal law is referred to as a small fish without importance or real authority. He is a pound of flesh sacrificed to Shylock, as in The Merchant of Venice. Now, is this pound of flesh innocent or guilty? That is for you, your honors, to determine. In light of the totality of the evidence, once you are satisfied that the court is competent and the trial is fair, in your deliberation, you will take into account of the fact that the Office of the Prosecutor failed to carry out the minimum verifications that Mr. Abd-Al-Rahman was indeed Ali Kushayb, and, on the contrary, presented evidence that he was not. That the OTP claimed to establish that he was Agid al-Ogada, and as such that he was a Janjaweed leader, without defining these two terms, and therefore failed to prove this, and also failed to prove the mental element common to all crimes. And on these grounds, and as a consequence of all the other grounds raised by the defense, you will acquit, your honors, Mr. Abd-Al-Rahman of all the charges against him. My closing arguments are over, with one exception. I would like to thank all the members of the team present in this chamber or who have been here before. Some of them are in the public gallery, And even I'd like to also thank those who are not present at all. And when I say members, I'd like to also include our interns who, throughout this trial, have provided very precious support. I would also like to very warmly thank my colleagues from across the room. Every time the topic was brought up in our team, in our discussion, we said we're lucky with the teams from the Office of the Prosecutor and the legal representatives of the victims. Things are going well. And I said, yes, indeed, we're extremely lucky. And the criteria that shows that we're lucky is that every time things don't go well, it's surprising. We're surprised. So because of this surprise, it means that collegiality has been good throughout, and I'd like to thank them for this. And last, I'd also like to thank the staff of the court. Their work is very precious. And last but not least, I'd like to thank your honors, Madame Aline Gonsou, Alexis Windsor, and Judge Jana Corner. I'd like to thank you for the excellent management of this case, despite what the defense's arguments might be. And now I will take my seat and I will give the floor to Mr. Abd-Al-Rahman.
Thank you, Mr. Lecce. Yes.
Mr. Abd-Al-Rahman, in the name of God, praise be to God, and prayers and peace upon the messenger of God. First, I would like to thank the distinguished judges for allowing me to speak today at this conclusion of my trial. My name is Ali Muhammad Ali Abd-Al-Rahman. I was born on the 1st of January 1949 in Sudan, in Niala state, in the southwest Darfur, in the locality of Rahad al-Bardi. I belong to the Taisha tribe. The Nazir of the Taisha tribe is Mahmoud Abd-Rahman Bishara Ali al-Sanusi. He is one of the grandsons of Abdullah Taishi, who was known throughout Sudan in general and in Omdurman in particular. The Taisha tribe is a tribe of peace. In fact, it does not have any conflict with other tribes. It welcomes all the tribes that wish to live in peace in Rahad al-Bardi, such as the Fur, Zagawa, Bargo, Al-Tama, Al-Qamar, Al-Fallata, and Al-Mima. All these tribes live together in Rahad al-Bardi under the leadership of the Nazir of the Taisha. There was also the Salamat tribe, but they did not want to live in peace with other tribes, so they had to leave. The Taisha tribe did not participate in the tribal wars, neither did it take part in the insurgency nor in the counter-insurgency. This is why all the tribes that wish to live in peace prefer to live in Rahad al-Bardi. Lots of false things were said about me and about what I was doing in 2003 and 2004. I did not give my testimony during the trial, but I still want to respond to what was said. And I would like to apologize to the judges if my words, or if I did not choose my words well, or my words did not go in line with what they would expect because of my lack of education and culture. These are the words of a simple Sudanese citizen who joined the army at the age of 15 and became a nurse. And these are my words. First, false things were said about my pharmacy. It was a pharmacy to treat human beings and not animals. In the army, I learned how to cure human illnesses, and that is what I was doing, and this is what I did in 2003-2004 in Garcilla. I had a small pharmacy in the market. I used to treat all those who came to me, to the pharmacy, whether they were Arab, Fur, Zagawa, or Masalit, without any distinction. We are all brothers. We were all created by God. We are all brothers and sons of God. The Fur are my brothers, and I served them as such at my pharmacy. Umda Harun Hid, may God watch over his soul, who was the Umda of the Fur in Garcilla, so he knew this well. He would send the people of the Fur to get their medicine from me. But he knew very well, around 2009-2010, he knew this very well. And when I went back in these years to Rahad al-Bardi, some of the Fur people came looking for safety. They came from everywhere. They came from Mukjar and Delej. First, they had gone to Dambar, where they did not feel safe, so they came to Rahad al-Bardi, where we received them very well. I had a plot of land there at the time. And some of the Fur who arrived stayed on my land for a while until houses were found for them. And it was normal to welcome them. In 2003-2004, I traveled a little. My main family was with me in Garcilla. Therefore, I did not need to return to see them in Rahad al-Bardi. At that time, my medicines were delivered to me from Niyala. I used to buy from a Greek Orthodox merchant who is called Al-Batal. I used to ask the people who used to travel to Niyala to bring me the medicines to the shop. I did not have a car to go there myself. I have never owned a car, and the only car that I used for transport was the Central Reserve Forces service car, and that was starting 2005. And starting 2005, like everybody else, I heard what was being said about the events in the region. There was the rebellion attacking and the army fighting back and driving them out, and with the help of the PDF in the area. It was terrifying, and thanks to God, Garcilla has never been attacked. And I have also never seen the Janjaweed in Garcilla. And the Janjaweed only entered the cities that they wanted to attack. And the Sudanese army, led by the Popular Defense Forces in Garcilla, with the help of the Agids. So they were working with they were mobilized from several tribes such as Nawaiba, Salamat, Bani Halba, Sharaifa, Jazam, Ben Hassan, Zagad, Ben Hussein, Musaira, and others. And there was no one from the Taisha tribe in Garcilla. And I was one of the few Taisha people there. Therefore, there was no popular defense forces from the Taisha mobilized in Wadi Saleh. And the Nazir of the tribe, Abd-Al-Rahman Bishara al-Sanusi, may God bless his soul, had said that the Taisha should stay away from conflicts. In any case, back then I was 54 years old, and I was too old to join the popular defense forces. And then I had to run my pharmacy to feed my family. So I couldn't give up everything to go and fight the rebels. And after spending 27 years in the army, I had done my time. And by March 2004, The situation had gone really bad, and my pharmacy was no longer enough to sustain a living. And there was a person from the Central Reserve Forces who told me that they were recruiting and they needed a nurse. I was too old, but General Ammar, who was their leader, gave me his permission to be recruited and to serve as a nurse. And that's how I went into service. I stayed in Garcilla during this recruitment period, and then I went to Al Ubaid for training. I did not need to do basic military training because I had worked for 27 years in the army. I only took additional training that was allocated for the police. I graduated in 2005 and I was given the rank of Musa'id or warrant officer because that was the rank that I had when I left the army. First, I served in Garcilla and then I moved to Rahd al-Bardi. As for my surrender to the International Criminal Court, no one brought me here. I came out of my free will because I have nothing to do with the accusations against me and nothing to do with everything said by the organizations and journalists on the radio. I have come here so that the court would look into my case and tell me what my fate is. I said on the phone that my name was Ali Kushayb because I had been waiting for 2 months in hiding, moving around all the time. And I was warned that the government wanted to arrest me, and I was afraid of being arrested. I was desperate. The court did not want to talk to me if I did not say that. So as soon as I said it, they started taking care of me. But that is not true. I am not Ali Kushayb. I don't know this person. I ask for the forgiveness of the court for this lie. If I hadn't said this, the court wouldn't have received me, and I would be dead now. I thank God for creating this court that gave me a place where I can find justice. I have spent more than 4 years here, and I still don't know what my fate is. I have a family of 25 persons waiting for me in Sudan, and I'm the only one responsible for them. And among them there are small children. This family needs food, education, medical care, and moral support. And the young children are in particularly in need of their father, who can teach them how to be men in the service of God and not to give up to temptations by the devil. I have already lost 2 of my sons since I came here without being able to be by their side in order to show them the right path. And I was not able to visit their graves. I pray to God every day so I don't lose any more of my children. I am here in the detention center. So I'm here in the detention center, and I have been sending them the money that I earn. But I don't know the fate of this family. They are waiting to know my fate as well. I thank God for this ordeal and pray to Him to take care of my family until I return. And thankfully, the war has not reached Rahd al-Bardi yet, and I hope that it wouldn't. War is a scourge. Sudan was a great country. The Sudanese people only aspire to one thing, and that is living in peace, the peace of God. Sudan is a rich country and prosperous country, and on its own it has the capacity to feed the entire African continent because it is rich in resources, livestock, gold, silver, minerals, agriculture projects, sugar, cement, and textile factories. The Sudanese people is rich in educated people such as teachers, engineers, and doctors. And the International University of Africa was a beacon of knowledge that attracted students from everywhere around the world. Because of the war, all of this is ruined and destroyed, and the Sudanese people are suffering. They suffered in 2003, 2004, they suffered before, and they have suffered since then, and they are still suffering now. Everybody is suffering regardless of their tribe. I have lost 2 sons to the war since I arrived here. I know what I'm talking about here. This was a great loss, and I know lots of people who died because of the war. So there are lots of people who died. They went up to Khartoum from Darfur, the Nuba Mountains, and Obeid, the Blue Nile, and the south, because people made them believe that they were going to improve their life by demonstrating, and then they were killed there. I asked God to keep them in His paradise. There are people, when you ask them where their children are, they say that they are in Khartoum, and they haven't heard of them. And in truth, they are in Khartoum, but they are underground in graves, buried in the Ahmed Siddiqui Cemetery and Ben Habad al-Nil and others. The victims of 2003, 2004, and of today are my brothers and sisters. I pray for their salvation, and I suffer with their families, for whom their absence has caused an eternal suffering. If I had done the things they say I did, I would not be able to get over this. But I asked God to give me the strength to endure, just as to endure God's punishment, because just like brothers cannot fight among each others. So I pray God the Merciful to bring peace to Sudan, and that all the brotherly Sudanese people will be reconciled, and that they will renounce political quarrels, that everyone can return home, and then they can rebuild a prosperous and glorious Sudan in the light of God. I pray that my fellow doctors who had gone abroad will return to Sudan in order to care for the wounded and the sick. These are among the best doctors in the world. They are surgeons, pediatricians, dermatologists, psychiatrists, anesthesiologists, ophthalmologists, and dentists. Most of them left Sudan, and only a few remained. And those who remained are defying all the dangers in order to care for people, and they are risking their lives for this. I pray that the doctors will return to Sudan and provide support and help for the Sudanese people. I also pray that teachers will return to Sudan and resume education that the children need. Children are on the streets without education and without work. It is the grim promise of new tragedies for the future if the teachers do not return soon. I also call upon the civil servants, the leaders of tribal administrations, and the religious leaders on whom the moral structure of the Sudan is based to work together to restore peace and to recall the virtues of peaceful coexistence, tolerance, and love. There should be no place for racism, tribalism, or hatred. We are all Sudanese citizens. We are all Sudanese citizens, and we must work to restore peace and prosperity to our beautiful country, for our common salvation, and for the future of our children. I pray God for the fighting to stop, and that for the reconciliation of my brothers in order to rebuild in the peace of God. Politics had led them to hell, and may God guide them to good. Religion is Islam and not weapons. At the end, I would like to thank the judges. I would like to thank the defense counsel, the defense counsels. I would like to thank all the lawyers and counsel who participated for their work, for their appreciation and efforts. I would like also to congratulate the great Sudanese people and tell them, peace of God and mercy of God be upon you, and only what God wrote for you will happen. Peace be upon you.
Yes. Very well. What we'll do is we'll adjourn now until 2:15, 2:15, and then we'll deal with responses to the judge's questions, which haven't already been dealt with. Yes, so 2:15, please.
All rise. We will.